On October 12, 2018, Mesa, Arizona witnessed a sentencing that turned a private nursery into a public record. Danielle Morrow, 28, received a state sentence of 20 years for attempted murder and aggravated child abuse. But what drove an expected nap routine to match a precise schedule of oxygen crashes? The crime timeline opened on March 5, 2018, when a 6-month-old boy arrived at a pediatric ICU after a reported apnea episode during a daytime nap. The mother's account described sudden silence on the baby monitor and frantic CPR. Emergency physicians noted intermittent desaturation without infection or congenital defect. Over the next 6 weeks, similar events repeated after daytime naps only, never overnight, always on weekdays, never on weekends. On April 23rd, a second admission prompted a child protection consult. On April 29, a caregiver friend who occasionally helped in the home activated a dormant cloud feature on the nursery camera, a plush teddy with a pinhole lens, and began routing clips to an off-site account. On May 2nd, the infant suffered another episode at 1300 hours. The video stream showed the room light brighten, the bear's LED reflect in the window, and a hand in a gray sleeve enter the crib area for less than 30 seconds. 30 minutes later, desaturation alarms sounded in the monitor log. Morrow, born in Tucson and raised in a military household, had a nursing assistant certificate and short stints in 2 clinics. Colleagues described punctuality and an obsession with infant sleep trackers, strict nap blocks, exact feeding volumes, rigid schedules. There were no prior arrests. Financial records showed mounting credit debt and a short-lived social media account centered on preemie advocacy, with a pattern of posts coinciding with the child's hospitalizations. Investigative focus shifted from medical to environmental. The pediatric team initiated covert continuous video EEG and oxyhemoglobin monitoring. No seizure activity surfaced. A forensic pediatrician advised controlled observation at home with hidden video. The Teddy camera, placed by the friend without Morrow's knowledge, recorded 3 weekdays. The crucial file on May 2 captured Morrow entering at 12:30, adjusting a blanket, and placing a thin, folded muslin over the infant's nose and mouth for brief intervals while watching the baby monitor tablet. Time codes on the tablet's screen mirrored in the Teddy's lens flare, aligned to a 5-minute alarm cycle. A cloud audit showed remote deletions from the main account minutes after each event. The off-site mirror preserved the originals. The baby monitor's app log registered manual alarm mute taps, and the home router's DNS history showed repeated logins to the camera interface. In parallel, a smart scale app recorded incremental formula top-offs timed to hospital discharge windows, implying manipulation of feeds to amplify desaturations. A state digital forensics lab verified hash integrity of the video files and correlated router logs, baby monitor notifications, and hospital telemetry. On May 25th, detectives executed a search warrant. They seized the baby monitor tablet, the Teddy camera, a phone, and a spreadsheet titled Nap Baselines, with columns for time, saturation naders, and ER success. Morrow was arrested for attempted murder, child abuse, and evidence tampering. A grand jury indicted on attempted first-degree murder and 2 counts of aggravated child abuse. Trial opened September 10, 2018. The prosecution's theory emphasized calculated induction of hypoxia and a pattern known clinically as fabricated or induced illness. The defense argued misinterpretation and standard soothing techniques. The jury convicted on attempted second-degree murder and 1 count of aggravated child abuse. The judge imposed 20 years on the attempted murder count and 5 years concurrent on the abuse count. with parole eligibility after 15 years under state guidelines. A motion for new trial based on improper admission of mirror cloud evidence was denied. An appeal challenging the warrant scope remains pending. Morrow is housed in a state women's correctional facility. Department records list completion of a cognitive behavioral program and a disciplinary infraction for contraband messaging. The child resides with relatives under a permanent guardianship order, with pediatric follow-up documenting normal development. The doorbell ledger. On May 9, 2021, Nottingham, England, witnessed a murder conviction tied to a garage that never slept. Kira Patel, 32, received life imprisonment with a minimum term of 22 years for murdering her partner and endangering a child. But how does a victim die of carbon monoxide exposure in a garage where the car ran longer than its fuel tank could allow? The sequence began on September 28, 2020, when emergency services responded to a semi-detached home at 23:30. A man was found unresponsive in the internal doorway between kitchen and garage. A toddler slept upstairs. Patel told responders she fell asleep watching television and awoke to an alarm. Paramedics recorded elevated carboxyhemoglobin levels consistent with exhaust exposure. The man was pronounced dead at hospital shortly after midnight. The attending physician flagged inconsistencies. House windows closed on a mild evening, garage door sealed with a draft excluder, car engine off upon entry but hood warm to the touch. A coroner opened an inquest. Patel grew up in Leicester, studied retail management, and moved to Nottingham 2 years before the incident. Financial records showed recent policy increases on life insurance for her partner and a short-term loan in arrears. Neighbors reported frequent package deliveries of smart home devices during lockdown. Detectives canvassing the street pulled video from a neighbor's doorbell. The motion log, rendered as a series of low-resolution thumbnails with timestamps, displayed Patel stepping out of the garage at 2200 hours, carrying a folded blanket, then re-entering at intervals of roughly 10 minutes until 23:20. A second neighbor's doorbell recorded muffled idling noise peaking at 2 distinct bursts, as shown by the app's automatic suspicious event markers. Inside the home, forensic scene examiners found a carbon monoxide detector with a new battery but disabled alert tones in the app settings. Data warrants extended to Patel's phone, the car's telematics, and the smart garage door controller. The car's data showed engine-on durations totaling 1 hour and 40 minutes, with 2 ignition cycles. Fuel remaining at shutdown was insufficient for that duration under factory consumption norms. The garage controller logged door closures at 21:55 and door openings at 23:32 by a user named admin. Router logs placed Patel's phone at home Wi-Fi for the entire window. A handheld CO meter used by first responders had captured a reading of 30 parts per million in the living room and 80 in the garage, trending downward, numbers consistent with engine shutdown shortly before the call. A search of Patel's cloud accounts revealed a PDF titled CO Staging, cached from a forum, and a shopping order for exhaust extension tubing. The tubing was found in a wheelie bin behind the house bearing soot residue. An autopsy confirmed carbon monoxide poisoning without other trauma. A consulting engineer testified about the mismatch between engine runtime and fuel capacity, concluding deliberate refueling or staged intermittent idling. The doorbell sequences, synchronized across 2 properties, formed a timeline that negated accident. Patel was charged with murder and child cruelty. The Crown's case argued a planned killing to secure insurance, with the child endangered by exposure. The defense suggested a tragic experiment to warm the car for a morning errand gone wrong. The jury convicted on murder and acquitted on cruelty. The judge imposed life imprisonment with a minimum term of 22 years. An appeal alleging improper admission of telematics as hearsay failed. The Court of Appeal found the data admissible as business records. Patel is incarcerated at a Category A women's prison. Prison records indicate enrollment in a bereavement program and restricted privileges after an illicit phone seizure. The child was placed under a special guardianship order with maternal relatives and remains under pediatric surveillance for any delayed sequelae.
On the 26th of October 2016, in Polk County, Minnesota, a legal resolution was reached in a case that led to a rural lake road being temporarily closed through traffic for safety improvements. Lena Hofstad, age 29, entered an Alford plea to charges of attempted second-degree murder and felony neglect, receiving a 25-year sentence with the possibility of parole after 17 years. The incident occurred near Lake Morrow's north turnoff around 7:30 p.m. as daylight faded. Hofstad called 911, reporting a near collision with a pickup truck that caused a stroller to roll down an embankment. First responders found a toddler, cold but alert, with minor injuries near the lake's edge. The road was dry, and the weather had been clear for hours. No pickup truck matching the description was ever located. Investigators pieced together evidence from multiple sources. A cyclist, unaware of the incident, had recorded his evening ride using a helmet camera that saved short clips. One clip, timestamped at 7:29 p.m., showed a stroller partially over the road's fog line and a woman's arm extended, with no vehicles approaching. A deputy discovered the cyclist's ride on a public tracking app and obtained the footage. Additional evidence included a fisherman's rear-facing dashcam, which showed Hofstad's car parked off the shoulder without hazard lights at the same time. The car's event recorder noted a door opening at 7:26 p.m. and closing at 7:30 p.m. A nearby traffic sensor showed no oncoming vehicles for 2 minutes, casting doubt on the reported near miss. Weather records confirmed no recent rain, and the toddler's clothing had lake water but no mud, suggesting the stroller was intentionally moved rather than accidentally slipping. Hofstad, raised on a farm near Crookston, had completed 1 year of college and worked seasonally at a packing plant. She had one prior child protection report for leaving a toddler unattended in a vehicle. Court records showed a recent custody dispute with the child's father, with temporary visitation orders pending. Her phone contained searches for topics like lake accidents and dashcam deletion. A search warrant uncovered a deleted photo from the roadside, taken moments before the 911 call, and a cloud backup revealed a similar attempt at the same location a week earlier, stopped when traffic approached. Investigators used the cyclist's footage, which included landmarks like a mile marker and a guardrail post, to reconstruct the scene. Experts determined the stroller's position suggested deliberate placement rather than an accidental drift. Financial stress was noted, with Hofstad facing overdue rent and a denied utility bill extension. A small insurance policy with an accidental death clause was also documented. The county attorney initially charged attempted first-degree murder and felony neglect. Hofstad's attorney negotiated the Alford plea, allowing her to maintain the incident was an accident while acknowledging the evidence likely supported a conviction. During the 26th of October plea hearing, the court reviewed the evidence, the helmet camera timestamp, traffic sensor data, dashcam footage, and the absence of another vehicle. The judge sentenced Hofstad to 25 years for attempted murder, concurrent with 5 years for neglect, with parole eligibility after 17 years under state law. The child's father provided a victim impact statement, emphasizing the child's ongoing medical and developmental support. Hofstad is now in a state women's facility, with limited family visitation per her case plan. She is enrolled in parenting and standard rehabilitation programs, though no substance use issues were confirmed. The child lives with their father under a custody order and receives early intervention services. Following the incident, county road crews extended a guardrail at the curve for added safety. The helmet camera manufacturer issued a brief advisory to cyclists about preserving video metadata for law enforcement, a small but significant outcome tied to a single saved clip, the parking garage loop. On August 12, 2019, Dallas, Texas, witnessed a conviction that treated a parking structure like an unwitting witness. Tara McNeil, 34, received 28 years for injury to a child causing serious bodily injury, with parole eligibility after 14 years, after her toddler died in a locked car during a workday. But how does a daycare sign-in appear in a parent's memory when the system shows no scan at the door? The timeline began on June 18, 2019, a day of extreme heat with an afternoon high near triple digits. McNeil told police she dropped her child at daycare shortly after 8 and drove to her downtown office. At 16:30, she returned to the daycare and was told the child never arrived. She ran to her vehicle 2 blocks away. Responders found the toddler in a rear-facing seat, unresponsive. Pronouncement occurred at the scene. McNeil described a memory gap, saying she ran late, parked, and went upstairs, believing the drop-off had occurred as usual. McNeil grew up in East Texas, studied business at a community college, and worked in claims processing. She lived in an apartment 10 minutes from both the daycare and the office. Employment records showed mandatory productivity targets. Messaging app logs captured a morning complaint to a coworker about an audit. She had no prior arrests. Financial records indicated on-time payments and no recent large purchases. There was no life insurance policy on the child. Investigators gathered records from the daycare's RFID-based sign-in and camera system, the office tower's garage license plate readers, and nearby traffic cameras. Daycare logs showed no badge scan for McNeil or the child that morning. A camera over the daycare entrance did not capture her vehicle or stroller between 7:15 and 9:15. By contrast, the parking garage recognized McNeil's plate at 8:06 entering level 4 and at 12:02 when she moved the car 1 row over, then again at 15:58 when she walked down the ramp rather than using the elevator. A dashcam in a neighboring car, set to parking mode motion capture, recorded McNeil passing the vehicle at noon, placing a paper bag in her back seat without looking into the child's seat. The office tower's elevator logs showed her badge used at 8 to 10 and 12:06, with a 35-minute gap around lunch when she remained within the building. Cell site data placed her phone in the tower throughout the day, with a brief step onto the garage walkway at noon. Vehicle forensics showed the child lock engaged, all windows closed, and no mechanical defect. The car's infotainment retained system timestamps. At 8:09, the phone disconnected from Bluetooth. At 12:04, it briefly reconnected, suggesting she opened the driver door. At 16:01, it reconnected again. A smartwatch paired to her phone recorded no significant steps between 8:30 and 11:55, then a short burst at noon consistent with a walk to the garage and back. Medical examiners determined hypothermia as cause of death. Prosecutors charged McNeil with injury to a child by omission, alleging knowingly leaving a child in a vehicle. The defense framed the case as a memory failure with no intent, citing stress and routine disruption. The state's case leaned on the parking garage's layered records, the noon bag placement captured by the neighboring dashcam, and the absence of any daycare check-in data. A human factors expert explained prospective memory lapses. The state argued the noon visit provided a clear chance to see the child and intervene. The jury convicted on the charged offense. The judge imposed 28 years, calling the noon return a decisive factor. A motion for new trial based on juror exposure to media was denied. McNeil is incarcerated at a state women's facility in Gatesville. She is eligible for parole consideration after 14 years under Texas law. The daycare replaced its RFID scanner with a turnstile that physically blocks entry without a scan. The garage operator began retaining parking mode footage from tenant dashcams for 72 hours upon request, a policy change spurred by a case in which cameras designed for commuters became evidence custodians. The thermostat winter. On January 14, 2022, Calgary, Alberta, witnessed a second-degree murder sentence built from a home's heating history. Nadia Petrescu, 31, received life imprisonment with parole eligibility after 15 years for the hypothermia death of her infant son. But how does a thermostat's timeline survive a factory reset? The event began on December 8, 2021, during a cold snap that drove temperatures well below freezing. Petrescu called emergency services at 6:50 a.m., reporting a furnace failure and an unresponsive child. Responders found a frigid nursery with an open window, a space heater unplugged, and frost on the inner sill. The infant arrived at hospital with core temperature far below normal and could not be revived. A city outage map showed no recorded gas or power interruptions on that block. Neighbors' furnaces ran without incident. Petrescu told investigators the thermostat had malfunctioned overnight, and she opened the window briefly to vent a fuel smell. The thermostat on the wall displayed a default setup screen, as if newly installed. Petrescu emigrated from Romania as a teen, completed a medical office assistant program, and leased a small basement suite in a split-level home. There were no prior arrests. Pay stubs showed reduced hours in late autumn. A pending insurance rider for accidental death on a store card policy listed her child as the insured, effective 2 weeks before the incident. Friends described meticulous budgeting and frequent purchases of smart home devices during pandemic lockdowns. Investigators secured a warrant for cloud records tied to the thermostat account. The manufacturer provided server-side logs showing manual mode changes and window sensor integrations. Between 2200 and 2200 hours, the thermostat registered 6 manual overrides to Eco at 50, 2 degrees Fahrenheit, then a final hold at 48. A connected window contact sensor reported open status from 2332 to 647. The thermostat also recorded a local reset at 6:49 minutes after the emergency call, which wiped local schedules but not the hosted history. The gas meter telemetry showed normal supply pressure and steady draw from other appliances. Inside the nursery, an environmental data logger used for baby sleep tracking, mounted under a shelf, contained a micro SD card with minute-by-minute temperature and humidity. The curve showed a gradual fall aligned with the window sensor timeline, not the abrupt drop expected from a true furnace outage. The space heater's plug revealed no arcing or failure. The heater's internal memory showed it had been powered on for only 20 minutes that night. A broader digital sweep found search queries on Petrescu's phone for thermostat reset without history, eco mode overnight, and how long to get hypothermia in cold room. Purchase receipts indicated a magnetic window draft blocker delivered 3 days earlier and installed elsewhere in the home, but not on the nursery window. A neighbor's exterior camera, facing the shared driveway, recorded Petrescu returning to her door at 21:48 with a small toolkit. Later, at 23:30, she stepped out briefly in a sweater, then re-entered. No one else entered or left through the night. Utility logs and device histories converged on a controlled cooldown rather than a mechanical failure. The Crown charged Petrescu with first-degree murder, alleging planning and deliberation, and with interfering with a device to obstruct justice. Defense counsel argued an accidental misconfiguration and panic-driven resets. Forensic testimony focused on the resilience of server logs after local resets, the synchronization of window sensor and temperature traces, and the absence of any furnace fault codes. On November 29, 2021, a week before the death, the thermostat history also showed a 2-hour test period with similar cold settings, undermining the defense's claim of unfamiliarity. At trial, the jury rejected first-degree but convicted on second-degree murder. The judge imposed life imprisonment with parole eligibility after 15 years, noting the calculated nature of the environmental manipulation and the immediate reset after the call. An appeal claiming improper admission of cloud records as foreign business documents failed at a leave-to-appeal stage. Petrescu is housed at a federal women's institution in Alberta, listed as medium security. Correctional notes reflect enrollment in trauma and accountability programming. The landlord replaced the thermostat and sealed the nursery window. A city inspector documented no gas leaks or code violations. A child death review recommended clearer public guidance on cloud-stored device histories and emphasized that local resets do not erase server logs. The trail cam by the well. On March 3, 2018, Sawyer County, Wisconsin, witnessed an attempted homicide conviction shaped by a camera meant for deer. Bridget Larkin, 30, received 23 years for attempted first-degree intentional homicide, with parole eligibility after 15 years, after her toddler survived a fall into a farm well. But why did a wildlife camera wake at the exact minute of the fall, when no animals crossed its field? The incident occurred on July 22, 2017, at a family property bordered by second-growth woods. Larkin called 911, reporting that her child slipped through a warped plank and fell into a shallow, stone-ringed well near an old pump. volunteers and deputies arrived to find rope marks on the well wall and a child hoisted out by a neighbor moments earlier. The child suffered mild hypothermia and abrasions but stabilized quickly at hospital. Larkin described playing near the pump, a sudden cry, and an improvised rescue using a rope thrown by a passerby. The well area had been fenced years ago. The gate stood open with a rock propping it. Larkin, a part-time bookkeeper and seasonal farmhand, lived in a trailer on the property owned by her uncle. School records showed she left high school in 11th grade, later completing a GED. There were past county human services contacts for inadequate supervision. Bank statements revealed overdue bills and a recent application for a burial benefit rider on a credit union policy that did not issue when the insurer requested additional documentation. Deputies canvassing for witnesses learned that the uncle had mounted trail cameras to monitor deer movements along the tree line. One camera faced a fence line that included the well gate. It recorded in bursts when its passive infrared sensor detected heat motion. At 13:08, the camera captured 20 seconds of video showing Larkin entering the frame, removing the rock, opening the gate, and pulling the stroller through. At 13:10, it captured her returning alone to open the gate again. Seconds later, the camera recorded rapid arm movements at the well edge, and then a brief absence. At 13:12, a neighbor arrived in frame, waving and running toward the pump. The camera did not record the actual fall into the shaft because the well was outside its angle, but the sequence contradicted a narrative of a warped board and an accidental slip. A second trail camera, set on a different tree, took still photos at 1-minute intervals and showed no deer or other animals in the area for 20 minutes. A forensic examination of the gate and fence found fresh scrape marks consistent with stroller wheel hubs. The rock used to prop the gate bore recent skin oil residues in the pattern of a firm grasp. The well's inner wall held parallel vertical smears from rubber soles at a height, matching an adult brace during a kneel and reach motion. The neighbor's truck dashcam, which auto-started when the truck moved, captured Larkin standing, looking down into the well, and then stepping back as the neighbor pulled in. A phone analysis showed Larkin had searched for old well cover replacement cost and accidental death benefit child in the week prior. Her device's photo cache contained a deleted image of the well taken the afternoon before. Charges followed: attempted first-degree intentional homicide and child neglect. The state argued deliberate endangerment with the well as the instrument, supported by the trail cam timestamps and the gate manipulation. The defense offered accident and desperation, pointing to Larkin's attempt to call for help and the child's survival. At trial, the prosecution built a layered timeline: trail cam clips, dash cam arrival time, cell phone tower logs, and the absence of any wildlife movement to trigger the cameras at other times that afternoon. A reconstructionist testified that the stroller's front wheel showed fresh limestone dust matching the well surround, inconsistent with play on grass alone. Larkin was convicted on the attempted homicide count and acquitted on neglect as a lesser-included charge merged into the principal offense. The court imposed 23 years with parole eligibility after 15. A post-conviction motion alleging ineffective assistance based on failure to challenge the camera's motion algorithms was denied. The court held the recordings reliable when corroborated by independent sources. Larkin is housed at Taichida Correctional Institution. Prison records show participation in parenting classes and work assignments in the kitchen. The family fenced the well with chain link and poured a concrete cap. The uncle moved the trail cameras after the case, stating through counsel that he had installed them for wildlife, but learned they documented people more faithfully than animals. County Emergency Services added guidance for rural properties on securing legacy wells, an administrative footnote to a case proven by a sensor that watched silently for deer and saw something else instead. Across these cases, ordinary devices, thermostats, parking systems, wildlife cameras became the record keepers. Each timeline was built from small, independent traces that aligned. A server log that survived a reset, a noon walk to a garage captured from a neighboring dashboard, a motion-triggered clip that woke at the wrong moment. The pattern is not the brand or the gadget, but the redundancy. When one record can be erased, another remains to fill the gap.